Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Of course, this is Legal Friday, so joining me today, Alex Ooley of the Ooley Law Offices and the man behind the Forge of Freedom podcast. Alex, thanks for coming along today, man.
Yeah, great to be with you, Paul. Thanks for having me.
So a lot of legal stories. When we only do this every couple of weeks, there are a lot of legal stories we got to get in the mix and get caught up on. First is not really a legal story, but it's an Indiana story, and so I wanted to cover it with you. An AWR Hawkins story on Breitbart, and I covered this one a little bit on Wednesday. Democrats on the Indianapolis City Council voted Monday night to ban constitutional carry and concealed carry with a permit within city limits. Plan was part of Mayor Joe Hogsett's gun control package. Fox 59 reported that Hogsett's gun control bans assault weapons within the city and raises the minimum age for gun purchases to 21. I'm going to go ahead and leave the story there. The catch is Indiana has preemption, and so technically the city can't do what they just did. And when I originally covered this, I had a question come across, well, what if a city police officer decides to enforce city law? What happens?
Well, luckily, Indiana has the Indiana Firearm Preemption Act, which prevents local government bodies from making laws with respect to firearms, ammunition, etc. And so this law is completely unenforceable. But to your question, or to the listener's question, if an officer does try to enforce this, the Preemption Act has substantial teeth to it. It would require damages, number one. It would require attorney fees, and then triple damages, or what's called treble damages on top of it. So it would be pretty significant payout for the plaintiff and the attorney representing that particular plaintiff if this were if the law enforcement in Indianapolis attempted to enforce this.
So if an Indianapolis police officer does pull someone over, they should get and charges them with carrying even with a permit, or it's Indiana, carrying with or without a permit, they should find the most talented and expensive attorney they can get to go after this.
Yeah, there is a provision that says it has to be reasonable attorney fees, but of course, what that judges are typically pretty liberal with that because they were attorneys once and always fear that they may become attorneys again. So they try not to cut down on attorneys' bills too much.
All right, and that. What comes to mind when I was growing up, and this again is the 70s and 80s, $100 was a big deal, and $100 an hour was unthinkable. $100 an hour now is a very inexpensive attorney.
Yeah, most start out in the $250 an hour range, some upward of $500 for a good criminal defense attorney and for a good civil attorney for that matter. But the interesting part about this, too, is I'm not sure if that officer, ordinarily, that officer would be entitled to qualified immunity for, a particular act if that act hadn't been deemed to be unconstitutional by a particular case. But here, especially where the state attorney general has issued an opinion saying that this is unenforceable and contravenes the Indiana state statute, I'm not sure that the law enforcement officer who tried to enforce this would be entitled to qualified immunity. So I would be very nervous if I were an officer trying to enforce this ordinance.
All right. So in short, the police are not. I don't know if they're not allowed, but they are not supposed to enforce this city ordinance, and if they do, they are in deep doo-doo. So if you have a concealed carry permit, or if you are legal to carry in Indiana and you carry, don't necessarily be afraid of going into Indianapolis.
Yeah, that's right. at least not for that reason. Of course, like most major metropolitan areas that are run by Democrats who are trying to posture themselves politically for the next election, there has been an uptick in crime in lots of cities, and I think Indianapolis has been victim to that as well. And of course, the uptick in crime, the supposed reason they're coming up with this ordinance restricting the rights of gun owners is to prevent that crime. And of course, restricting our individual right to keep and bear arms would do nothing to stem violent crime in Indianapolis. I pulled up earlier today at crimeresearch.org, their Twitter page, which is of course run by John Lott, and he said, I thought this was an interesting statistic, that in 2021, 49% of active shooting attacks were stopped by citizens with permits to carry. And if you don't count gun-free zones, the number is closer to 60%. So that just demonstrates the importance of an armed citizenry toward stemming violence. Not only does an armed populace not contribute to violence, it actually helps stop violence.
Well, and I realized at the top of the show I forgot to mention, and we should absolutely mention it every time you're on, I am not an attorney, you are, but we are not giving legal advice here. This show is for education and entertainment only, not to be to be taken as legal advice. So, yeah.
And one other thing too I'd like to mention about this story before we move on is that there is a Republican running against Mayor Hogsett that unfortunately criticized Mayor Hogsett for not taking this sort of action sooner. So the Republican running against Mayor Hogsett is not a good alternative. So interestingly, Guy Relford, who you know and you've had on the show before, announced himself as a write-in candidate. He's not eligible to be mayor, but he announced that he would gladly take your vote as a write-in candidate, since we have two terrible options in Indianapolis.
So is there a primary he missed, or is there a...
I just don't think he's eligible because of where he lives.
Oh, okay.
Yeah.
All right.
He works in Indianapolis and Marion County, but I don't think he lives in Marion County.
All right. Well, at some
But I'm
point
sure there are lots of people who would love to have the gun guy as the mayor of Indianapolis. So.
Well, and let's be honest, for this kind of write-in candidate, what does it hurt? Because you've got two bad choices. Writing somebody in does not hurt a bit.
Right.
Let's go ahead. The next one, this one got my blood boiling a little bit, and I know the answer, but I'm going to talk with you about it anyway. This is off NBCConnecticut.com. Connecticut's ban on guns in state parks has survived a challenge. A federal judge dismissed a lawsuit where a man had argued the policy violated his Second Amendment rights. For folks enjoying the outdoors, there are mixed feelings about the current ban on guns in state parks and forests without authorization. The rest of it is a lot of drivel. The reason this lawsuit got dismissed is the state of Connecticut, my understanding is, has never enforced the rule, even though the rule is there. Therefore, since nobody has been charged with a crime, no one has standing to bring this lawsuit?
Yeah. So standing is often a way to dispose of lawsuits that judges don't like. If there's a colorable argument to use it as a way to throw out a case, sometimes they will do that. And it seems like that's what happened here. Now, where was this case? Was it in federal court? I didn't. It says it was about state parks, but I didn't.
It was a district court ruling. We are profoundly disappointed in the district court's ruling, which we believe is significantly at odds with the U.S. Supreme Court precedent.
Either way, if it was based on state law, even in light of Bruin, each state has its own standing requirements. So there may be specific standing requirements in Connecticut that don't apply in Indiana, for instance. But standing is just simply the capacity of a party to bring suit. And sometimes it requires actual harm, not just potential harm or theoretical harm. So that's going to depend on the jurisdiction in terms of the nuances of what is required for you to bring suit, to have the capacity to bring suit. So I didn't read the content of this case. I just read the news article, but I suspect the judge was using some technicalities in that regard in terms of what the specific requirements of standing were.
And I did just go back in the article. This is a federal judge. On Wednesday, a federal judge threw out a challenge to the rules. So yeah.
So it would be under the federal standing doctrine then that the judge made this ruling, and it seems like this is like many cases that we've seen after Bruin, judges making sort of an analysis to meet a particular outcome, a desired outcome, and I think that's clearly what was going on here.
I want to remind everybody that's watching that if you want to comment on any of these things, just go ahead and pop your comment in on the Polite Society podcast feeds. We'll get them. We'll put them on the air.
I'd like to mention too. Oh, go ahead, Paul. Sorry.
No, just go ahead. I was just going to ask because it sounded like I was starting to interrupt you. So go ahead.
Yeah. Well, I think this is a good time to mention this. I saw this earlier from the Firearms Policy Coalition Twitter page. They posted an abstract that they got from the Duke Center for Firearms Law, and it's interesting because what they're saying is basically all these states are implementing laws that they know violate Bruin, and despite violating Bruin, try to enforce them because they think that they will be protected by qualified immunity. Because, like I said earlier, for qualified immunity to defeat qualified immunity, there has to be a case basically factually the same that it's already been decided that would put law enforcement on notice that it was unconstitutional. So because these haven't been tested, they're basically saying, go ahead and enforce these unconstitutional laws because you'll be protected by qualified immunity at least the first go around. So it's a tactic, it seems like, to go ahead and enforce these unconstitutional laws despite knowing that they contravene Supreme Court precedent and the Bruin decision.
Yeah, I don't want to say I'm a fan of. I'm subjected to the TV show Cops on a regular basis because Susan watches it a lot and she enjoys it. And I would imagine having consumed the amount of the show Cops that I have, if the police officer is in New Jersey, if the police officer is in California, if the police officer is in Hawaii, are some of the three most egregious ones. By the way, some of the three most anti-gun states as well. Police in those states seem to be aggressive to the extreme, and I don't think would have a problem in the world enforcing any law that gets passed by their legislature, whether or not it's going to be shot down.
Yeah, I think by and large, law enforcement tends to be, somewhat pro-gun, somewhat anti-gun. It just more or less represents the general population in lots of ways, at least in terms of their perception of the right to keep and bear arms. So I think it's possible in most jurisdictions, and especially in anti-gun jurisdictions, to have enough law enforcement that are sympathetic to the gun control message. And if it's okay with you, Paul, I'd like to read just this short paragraph from this Duke Firearms Law abstract, because I think it's pretty enlightening in terms of this strategy to enforce anti-gun laws. It says, here we suggest an unlikely source of continuing power after Bruin for states to disarm individuals they deem dangerous. Qualified immunity. Qualified immunity shields state officers from monetary liability for many constitutional violations. In short, unless a previous case clearly established with high factual particularity that the officer's conduct was unconstitutional, the officer does not pay. Thus, a state law enforcement officer may, after Bruin, confiscate an individual's firearm if the officer deems that person too dangerous to possess it. The officer's justifications may conflict with the federal court's understanding of Bruin or the Second Amendment, perhaps flagrantly, but unless a previous authoritative legal decision examining nearly identical facts says so, the officer risks no liability. And because each individual act of disarmament will be unique, such prior decisions will be vanishingly rare. The result is a surprisingly free hand for states to determine who should and should not be armed, even in contravention of the Supreme Court's dictates. So that just shows you how nefarious this approach is to individual liberty.
I want to get a couple comments in here real quick. First from Warsaw Patriot, who I'm glad to see is checking in today. Blue or red states, doesn't matter anymore. Every state is trying to pull an unlawful law they deem as unconstitutional when it's BS. I'm going to defend my own state here a little bit. And I don't see, our session is done for the year. I didn't see anything go through the legislature this year that was blatantly unconstitutional that made it out of committee. So that's just for my my home state. And then MK says New York red flag law confiscation has gone from $1,400 a year to $9,000 in less than a year. You know what? I didn't have red flag laws on the schedule today, but that's one thing I hope makes it to the Supreme Court very quickly. I know it's in process, at least in the Fifth Circuit, but I don't think that the Supreme Court is specifically taking up red flag laws this coming fall.
Yeah, I kind of doubt that they will. There are obviously lots of other issues that are brewing. I think red flag laws are right up there with some of the most important issues, but as we've seen, there are lots of states around the country that are depriving people of their individual liberty in lots of different ways, and it's tough to prioritize which ones to put on the chopping block first. But I think, I'm like you, Paul, I hope that the Supreme Court takes up the red flag issue and ultimately strikes it down, because I think it's an egregious violation of our right to due process and secondarily the right to keep and bear arms.
All right, I am going to go ahead and move on to our next story here. A California federal judge, and this is off of the Firearms Policy Coalition's Twitter feed. That's why these are so short. The bites I have are so short. A California federal judge has thrown out a lawsuit challenging San Jose's gun insurance and fee ordinance, saying that only claims of plaintiffs can try amending are the non-Second Amendment ones against the fee. The judge says the ordinance does not condition ownership on complying with the insurance requirement because people can own guns without insurance and subject themselves to citations or fines instead. So, really, this is this one burns me. It's not unconstitutional because you can just go ahead and pay whatever the state decides your fine is. That's an infringement. I'm sorry.
Yeah, just to say that that's not a burden on the core right is just an absurdity. I mean, to say that, oh, we're not depriving you of the right if you don't have insurance because you can just pay the fine, that's just completely flies in the face of logic and the Constitution.
Yeah, it's that one. I've started, and I have to admit I have not read the full thing. I started to read the judge's ruling, got immediately so angry my head started to pound, and gave up after just 4 or 5 pages. So I didn't go all the way through it. I'm just getting my information off the Twitter.
Well, a key component of the opinion that I'll just mention is that when the court analyzed the insurance requirement under these historical analogs that we know we're supposed to look to based on the Bruin text history and tradition standard, they compared it to the old surety laws, but the problem and the distinction between the surety laws and the insurance requirement is that with the surety laws, that was somebody who had been determined to be dangerous or who had made some particular threat against somebody, and they didn't lose their right. They simply had to pay a surety to exercise their right. And unlike the insurance requirement, here in California, there is no finding of any particular dangerousness. It's just that they assume that everybody is dangerous and should have to pay insurance. And that's simply not the way that the surety laws worked, and I think is a faulty analog to look to.
Yeah. Let me, I just glanced over. Let me get a couple of comments in here again, going back to Warsaw Patriot for this one. The Illinois assault weapon ban literally banned everything. Even the Hunters Association and the Sheriff's Association and 33 state attorneys of Illinois are not happy with it. And he followed up with Amy Coney Barrett needs to take up the case on the spot. I believe that was up. It did make it up to her, but she declined to immediately bring it into the Supreme Court's purview in the fairly recent, within the last few months, right? Not that it won't get there, but she said let it go through the Seventh Circuit first.
Yeah, and courts are generally reluctant to short circuit the process, and they want to let the case go through the process, let it get fleshed out in the lower courts, let all the facts and the legal issues come to light, and let the lower courts do their job before it comes to the Supreme Court. And that seems to be the approach that Amy Coney Barrett was taking here in denying a early review of the case, essentially.
Yeah, it's and I do believe it will. Because and you and I have discussed this. The makeup of the 3-judge panel in the Seventh Circuit, Alex, is not that favorable. So it will probably get the wrong decision from them and then get appealed before it makes it to the Supreme Court. But I do believe it will.
I agree with that. And you're right that even though Judge Easterbrook, who is a very prolific and conservative judge, by the way, I think appointed by Ronald Reagan, he is very anti-gun, not friendly to the Second Amendment, and I think you're right. We will have an unfavorable decision at the Seventh Circuit, but they did say, and I think this was to avoid some embarrassment or some stain on the Seventh Circuit, they did say they would expedite the process, and I think that was part of the reason why Amy Coney Barrett denied an early review, because the Seventh Circuit put an accelerated deadline in place.
Absolutely. Our next one here, this is off of Reason.com, Eugene Volokh. On June 30, 2022, just a week after the Supreme Court decided the Bruen case, Delaware Governor John Carney signed into law a ban on assault weapons and standard capacity magazines effective immediately. Apparently, he didn't get the memo that a ban on firearms in common use is off the table constitutionally. Delaware plagiarized California's 1989 findings that it was imperative to ban any gun that is not a sports or recreational firearm. The state ignored the Delaware Bill of Rights guarantee of the right to bear arms for the defense of self, family, home, and state, and disregarded Heller's admonition that self-defense is the central component of the right itself. Delaware copied a definition from Connecticut that criminalizes a rifle depending on where one's fingers are placed when firing, and Maryland's long list of banned rifles such as the Colt AR-15. I'm going to go ahead. I'm going to copy this URL and I'm going to put it up in the comment section, both in Facebook and in YouTube, simply because Eugene Volokh does a great job of going into and explaining exactly why, on multiple levels, each part of the Delaware law is unconstitutional. And we'll see. There are, at the very least, I know SAF has a federal case right now they're challenging the Delaware law. We'll see where it goes from here.
Yeah, and this case is actually written by Stephen Holbrook. It's on the Volokh Conspiracy, which is, I think, edited by Eugene Volokh. And Stephen Holbrook, of course, wrote the book, America's Rifle, the case for the AR-15, which he goes into all of the arguments for the AR-15 and the legal defenses of it. And it includes this, as is mentioned in the article, this common use defense that we learned from Heller. It includes all arms that are in common use for lawful purposes, including self-defense, but not only self-defense. And as we know from Caetano, which said that stun guns were in common use, even though there were only a few 100,000 in circulation, the AR-15 is the most popular rifle in America. There are more AR-15s in the ownership of Americans than F-150s are on the highway, the most popular truck in America. So clearly, if any firearm, if any arm is in common use, the AR-15 certainly is. And of course, the anti-gunners often say, well, they're unusually dangerous, but there's a second component to that. They have to be not only unusually dangerous, but also not only dangerous, but also unusual. Dangerous and unusual, not one or the other. I don't think, first of all, that they're inordinately dangerous. They're no different than just about any semi-automatic rifle, so I don't think they meet that requirement. But even if you just assume, for the sake of argument, that they are unusually dangerous, they're not unusual, and by that I mean they're not uncommon. They're in common use. So if you don't meet both prongs, you don't get to use that argument.
Well, and as Holbrook pointed out in this article, the .223 round, which is what most ARs use, is not legal for hunting deer in several states because it's not powerful enough if you don't have a very good aim. The .223 will take down a deer if you've got the shot exactly where it's supposed to be. However, it wounds a lot of deer if your shot isn't spot on. So therefore, several states don't allow you to hunt deer with it. And so it's not very dangerous in a lot of people's opinion, in mine included.
Yeah, not exceptionally dangerous, and certainly in common use. The other thing, too, that Stephen Holbrook points out here correctly is that the anti-gunners repeatedly point to the wrong period of history. They use the antebellum history to support the post-Civil War history to support their anti-gun arguments, but that's not the era of history we look to. We look first and foremost to 1791, the time the Second Amendment was adopted, and then only look to later history to confirm our understanding of the history from the time of the founding and the adoption of the Second Amendment. So, and on top of that, the history they look to doesn't have particularly good history around it, because most of the gun control that they point to was a limitation on the possession of firearms by newly freed slaves. So that's not, there's a racist component to much of the history they point to on top of the problems otherwise.
Let me get a couple more comments in, then we got to start shutting it down. Warsaw Patriot again says, the 5.56/223 is used mostly for varmint like coyotes and prairie dogs. And then he follows it up with, well, a 308 will stop a hog or a deer. So you got to drop down 5 ARs for that one. Generally, if you find a 308, you got to go to the AR-10. So, and then MK says, baseball, hot dogs, apple pie, and ARs. Yes.
I like it.
We're going to go just a little bit long because I've got to get this in. Ever since the middle of the Barack Obama administration, I have sworn off of Chevrolet vehicles simply because they went from GM, meaning General Motors, to GM, meaning government motors. The federal government for a while owned a significant portion of that company, and I said I do not want a Barack Obama mobile. Supposedly that money has been paid back. I'm not smart enough to know whether the government got the full amount back or not. But even though it pains my heart to say it, I will never own a brand new Corvette. I cannot and will not go to anything from Government Motors for a new vehicle. So,
yeah. And I think that's a good point, and you could apply the same standard to the banks as well, because as we all know, many banks took a bailout, not just the car companies.
Yeah, absolutely. And we're going to go just even a little bit more late because we got a great comment that just popped in. And Warsaw Patriot is specifically asking you a question, Alex. In New Jersey and New York, there's a case with the armed Jewish community dealing with New York safe zones that prohibited them from using their concealed carry armed on their places of worship. I do believe that was an SAF case, and I do believe that has been decided in favor of those that wanted to carry in their place of worship.
Yes, I can't remember the name of the case, but if I can find it, I'll post it in the comments. I think we discussed that one. It's been a little while now, Paul, but I can't remember when that was. But I'm certain that we did, and I'll post that in the comments. I'll look for it after the show's over.
Alrighty. Well, speaking of show over, we're already over time, so I'm going to ask you, like I do every time you're with me, plug your podcast and, of course, anything else you want to promote today, man.
First off, thanks for having me, Paul. I always enjoy being on the show with you. Of course, I started the Forge of Freedom podcast at the beginning of the year. I care a great deal about the right to keep and bear arms and individual liberty more broadly. So I have my father on a lot on Mondays for Monday Gun Day to talk about a firearm-related issue. But on Fridays, I release a more broadly freedom-related topic. And we talked about Stephen Holbrook today. I'll be having him on as a guest in a couple of weeks to discuss his book, America's Rifle, the case for the AR-15. So keep an eye out for that. That should be released, looks like, I'm looking at the calendar here, July 28th. So that should be an interesting conversation. Keep an eye out for that. I'll also be, as a prelude to that episode, be talking about the anti-commandeering doctrine, which I've talked about on this show as well on a few occasions, which was a case, Prince versus United States, that was argued by Stephen Holbrook at the Supreme Court, and basically said that the federal government can't co-opt state and local officials to do their bidding. They can't commandeer state and local officials to do the work of the federal government. So that was a very important case, and like I said, one that was argued by Stephen Holbrook. So if the podcast is something that might interest you, you can find it on YouTube, on Rumble, and then on just about any popular podcast streaming platform.
Very cool. Alex, thank you again. Podcast listeners, thank you for listening. Viewers, thank you for watching us live. And commenters, thank you for commenting. You make these shows flow so much more smoothly, and you make it so much easier to do what I do when you comment. So thank you, everybody. We're going to go ahead and shut this down. Please do come join me tomorrow night, 7 p.m. Central Time, for the weekend edition of The Bullet. We'll discuss the major stories of the week, and we'll get multiple views on it. Thanks again, everybody. We'll see you next time.